Hello and welcome to the Blackstone Solicitors channel. Today, we're exploring a topic that might seem a little obscure, but can have a significant impact on homeowners, developers, and businesses alike. The right to light and the so-called 20-year rule. If you've ever wondered whether a neighbor's new building could block light to your property, or whether you can claim compensation for lost light, this video will guide you through the essentials. Imagine this. You've lived in your home for decades, enjoying a bright sunlit living room. One day, you notice construction starting next door. Over the months, a new building rises, and soon your windows are in shadow. It feels unfair, but can you do anything about it? This is where the right to light comes into play. In English law, a right to light can arise if a window has enjoyed natural light for at least 20 years without interruption. Essentially, if your property has received sufficient light through a window for 20 years or more, the law can protect that right. Any new development that significantly blocks that light may constitute a legal infringement, giving you grounds to seek a remedy. The 20-year rule is derived from the Prescription Act, 1832, a piece of legislation that recognizes certain long-standing rights acquired through continuous use. The idea is simple. If a window has been used to admit light for 20 years or more, the owner has a legal right to that light, and any obstruction by a neighbor could be actionable. It's important to understand that this isn't about mere inconvenience. The law focuses on whether the light is sufficient for the ordinary use of the room. Courts and surveyors often use a method called the Waldron method to assess how much light has been obstructed and whether it materially affects the enjoyment or value of the property. It's worth noting that rights to light are complex and context-specific. The 20-year period is critical. If the light has been enjoyed for less than 20 years, it is unlikely that a legal right has been established. Conversely, if the right exists, it can be enforced against any new development, even if the new construction complies with planning permissions. This often surprises developers who assume that planning approval automatically allows them to block light to neighboring properties. This is where specialist solicitors, like us at Blackstone, become invaluable. We advise homeowners, developers, and landlords on their rights and obligations, assess potential claims, and negotiate practical solutions to prevent disputes from escalating. Early advice can prevent costly litigation, protect property values, and ensure compliance with the law. In summary, the right to light and the 20-year rule protect long-standing access to natural light for windows. If a building has enjoyed light for at least 20 years, any significant obstruction by a neighbor could be actionable, potentially leading to compensation or modifications. Understanding your rights early is crucial. Don't wait until construction is complete or the light is permanently blocked. At Blackstone Solicitors, we help clients navigate these complex issues, offering expert guidance on property rights, neighbor disputes, and development law. If you're concerned about a new building affecting your property's light, get in touch with our team. We'll help you understand your options and act decisively to protect your home and investment. Thank you for watching. For more insights on property law, construction law, and neighbor rights, subscribe to our channel and stay informed about your legal protections.